Welcome back to the Constitutional Clarion and another video in this series on the dismissal of the Whitlam government. In this video, I'm going to discuss how two of Whitlam's ministers, Clyde Cameron and Jim Cairns, refused to resign when asked to do so by Whitlam and were then dismissed by the Governor-General on the Prime Minister's advice. Whitlam's advice to the Governor-General about the procedure for dismissing ministers and the justiciability of dismissal before the courts became important in relation to Whitlam's own dismissal, as we'll see. The way the constitutional system ordinarily works is that the Prime Minister is appointed by the Governor-General in the exercise of a reserve power, according to a convention that the person appointed is the one who commands, or is most likely to command, majority support in the lower house of Parliament. Then the Prime Minister advises the Governor-General on the appointment of other ministers. Whether a Prime Minister has a free hand in advising who to appoint is a matter for the relevant political party. In 1975, the Labor caucus would vote to decide who would become a minister, and then the Prime Minister had discretion to determine the ministerial office that they would receive, and then would make the relevant advice to the Governor-General for those appointments. If the Prime Minister lost confidence in a minister, perhaps because of a scandal or incompetence, the Prime Minister would demand the minister's resignation, and it would then be presented to the Governor-General, formalising that resignation from a ministerial office. But what happens if a minister refuses to resign? Now, this is extremely rare, but it happened twice during the Whitlam government. Under Section 64 of the Commonwealth Constitution, ministers hold office during the Governor-General's pleasure. This means that the Governor-General can dismiss a minister and would ordinarily do so on the Prime Minister's advice. But what if the minister denies any wrongdoing of which they've been accused? What if they insist on being heard by the Governor-General and receiving natural justice? Could a court then intervene if the former minister challenged their dismissal? Prior to 1975, there were at least two occasions upon which Commonwealth ministers refused to resign and were dismissed by the Governor-General. The first occurred on the 13th of December 1918 after a Royal Commission made findings of fraud in relation to the administration of the Navy. The Cabinet agreed that the Minister for the Navy at the time, Jensen, should be dismissed. Jensen contacted the Governor-General and asked him not to dismiss him until he had received the full details of what had actually occurred, which Jensen said he would send him. The Governor-General sought advice, and the acting Prime Minister, William Watt, advised him that it was necessary to dismiss Jensen in order to maintain public confidence in the government, given the serious findings of the Royal Commission. Jensen insisted on being heard by the Governor-General, but the Governor-General refused. The Governor-General then resolved this issue by requiring a meeting of the full Executive Council to be held to advise him on Jensen's dismissal. Jensen was permitted to attend the preliminary stages of this meeting, allowing him to put his case. The Executive Council voted for Jensen's dismissal, and he was duly dismissed. On the 3rd of March 1931, the Governor-General terminated the appointments of Senator Daly as Minister for Defence and Frank Anstey as Minister for Health. Now, this occurred after a spill of the Scullin Ministry on the 2nd of March 1931, at which both Daly and Anstey failed to be re-elected by the caucus. Both of them were supporters of Jack Lang and his plan to repudiate payment of interest on debt to British bondholders during the Great Depression. And on that, see my videos about the Lang dismissal. They refused to resign their ministerial offices, however, and were therefore dismissed by the Governor-General, Sir Isaac Isaacs. Isaacs had requested advice about whether this had to be done through the Executive Council or could be done by him personally as Governor-General. He was advised that Section 64 provides for the appointment and removal of ministers by the Governor-General alone, and that the Executive Council advice was not needed. These precedents didn't give a lot of guidance when Whitlam started to have trouble with his own ministers due to incompetence and scandals. In most cases, like that of Rex Connor, they did resign under pressure from Whitlam, but two of the ministers refused to do so. In May 1975, Whitlam decided to demote Clyde Cameron, who was Minister for Labor and Immigration, due to the manner in which he handled his portfolio. Whitlam asked for Cameron's resignation, but he refused to give it. Cameron, in a letter to Whitlam, which was conveyed to Kerr, insisted that the Governor-General's power to dismiss ministers was a prerogative power that could only be exercised for a good cause. He claimed that he was entitled to be heard by the Governor-General and that the rules of natural justice applied. He regarded the issue as justiciable, that means a court could hear it, and he said that the High Court would overturn any action by Kerr that was taken without giving Cameron natural justice. In Cameron's handwritten notes that are held by the National Library, it appears that he based his view upon early advice from the Attorney General's Department about a proposal to remove a judge of the Commonwealth Industrial Court. It had apparently told Cameron that while Parliament could initiate the removal of a federal judge, the judge had to be given notice of the complaint against him and be afforded the opportunity to be heard in his defence. Cameron translated that advice to his own position as a minister. Whitlam advised the Governor-General to dismiss Cameron without giving him the opportunity to be heard. He also advised that such action was non-justiciable. Kerr later told Sir Martin Charteris in the Palace Letters that Whitlam's advice was supported by appropriate legal and constitutional opinion. In handwritten notes by Kerr, it appears that he was told the advice came from Clary Harders, the Secretary of the Attorney General's Department, and then Kerr also rang the Attorney General, Kep Enderby, who gave the same advice. Kerr told Charteris that he accepted this advice and considered it his duty to dismiss Cameron without a hearing. He assumed that Cameron had legal advice and might challenge his dismissal on the ground that he had been denied natural justice. But Kerr concluded that such an issue could not have been justiciable in the courts. He stated that according to the legal advice that he'd received and in his own opinion, remembering Kerr was a former Chief Justice of New South Wales, Cameron's point was untenable. Charteris replied that he did not believe that the Queen had ever faced such a situation, but that he had no doubt that the course Kerr took in acting on the Prime Minister's advice and refusing to receive Cameron to hear his arguments is the same that would have been followed by all British sovereigns in modern times. Next, there was Jim Cairns. After the 1974 double dissolution election, Cairns was elected by the Labor caucus to be Deputy Prime Minister. It was hoped that his down-to-earth behaviour would operate as a brake on Whitlam's arrogance. In December 1974, Cairns became Treasurer. Various scandals ensued from his relationship with his private secretary, Junie Morosi, and more serious financial scandals including the loans affair. It wasn't just Rex Connor trying to raise loans for the government through Tirath Kimlani. Jim Cairns also sought to raise loans through a Melbourne businessman, George Harris. Cairns provided Harris with 4 letters in March and April 1975, empowering him to locate overseas loans. Cairns, despite being Treasurer, declined to tell the Treasury about what he'd done. The Secretary of the Treasury, Sir Frederick Wheeler, came across 2 of the documents. Cairns claimed that they were stolen from his private file. However they were obtained, Wheeler sought legal advice on them from the head of the Attorney General's Department, Clary Harders, but without telling the Treasurer. Harders provided advice on the 28th of May 1975, raising concerns that the letters created a legal relationship of agency between Harris and the Commonwealth Government. Wheeler then presented the legal advice to the Prime Minister, Gough Whitlam, and the acting Treasurer, Bill Hayden, while Cairns was on an overseas trip. Whitlam was furious and demanded that Cairns return to Australia. He required Cairns to provide all the documents that he held on the subject. When Cairns returned, Whitlam also demanded that he resign, but Cairns refused. Cairns eventually accepted demotion to a more junior ministry, which occurred on the 6th of June. Then, the opposition got its hands on another of the 4 letters. Before revealing this, however, it asked Cairns questions in Parliament about whether he had offered a commission of 2.5% on any loans secured. Cairns stated adamantly that he had not at any stage offered anyone a commission or to do anything other than make inquiries. But the opposition held in its hands a letter by Cairns telling Harris that the government would be prepared to pay a brokerage fee of 2.5% in relation to any loan that he procured. Cairns was then revealed as having misled Parliament as well as misleading the Prime Minister. When Whitlam demanded that Cairns reveal the location of all the letters concerning overseas borrowing, Cairns replied that each of the letters given to Harris had been returned and destroyed, but they hadn't. When all of this was eventually revealed, Whitlam insisted that Cairns resign from the ministry. Cairns refused. So Whitlam again asked the Governor-General to dismiss one of his ministers. He had arranged to meet the Governor-General at 8 p.m. on the 2nd of July to formally advise the dismissal of Cairns. At 7:30 p.m, Junie Morosi rang Kerr's office asking that Kerr speak to Cairns. Kerr declined, but said that he would call if any need to talk to Cairns arose. Then Cairns directly rang the Governor-General's office, stating that he knew the Prime Minister's advice and he was asking to be heard before the Governor-General made his decision. Kerr again declined to listen to him. When Whitlam arrived for the meeting, he tendered formal advice to the Governor-General to dismiss Cairns and not to hear anything from Cairns. Kerr acted upon that advice and did not give Cairns natural justice. Kerr took the view that he was legally entitled to hear the ministers he was about to dismiss, but was not legally bound to do so. He considered that it was the Prime Minister who had to take responsibility for the dismissal of his ministers. Now, this is of relevance because it set up the Whitlam dismissal later in 1975. It was Whitlam himself who had impressed upon Kerr that his power was a prerogative one, that it could be exercised without giving the dismissed person any opportunity to respond and dispute it, and that the action would be non-justiciable, so it couldn't be challenged in a court. When it came to Whitlam's own dismissal, under the same constitutional power to dismiss ministers in Section 64 of the Constitution, Whitlam's prior advice that the matter was non-justiciable opened the way for consulting judges, which would have been problematic if the action were justiciable. It also meant that dismissal could be swift without providing any period of time in which Whitlam would be able to respond, defend himself, and take any other course of action. Kerr said in his memoir, quote, "The advice tendered to me by Mr. Whitlam on legal and constitutional grounds that a minister has no legal right to be heard before being dismissed under Section 64 applies to the Prime Minister just as to ministers generally. When later I came to the decision that he and his ministers should have their commissions withdrawn by action under Section 64, the law applicable was the same law that he and I had previously agreed should be applied to Mr. Cameron and Dr. Cairns. In dismissing Mr. Cameron and Dr. Cairns, I was exercising my legal powers on the Prime Minister's advice. In dismissing Mr. Whitlam and his government, I was acting at my own discretion, but the law applied in all 3 cases was the same. There is no legal right to be heard before a dismissal under Section 64, unquote. So Whitlam did accidentally advise upon his own dismissal, at least in relation to the procedure by which it took place and whether it could be challenged in the courts, which is perhaps why he chose not to seek to challenge it himself. Thank you for watching the Constitutional Clarion, and I look forward to seeing you next time for a video on how Whitlam also advised the dismissal of a vice-regal officer, Sir Colin Hanna, from his office as Administrator of the Commonwealth, again without warning or natural justice. I'll see you then. Goodbye.